Good evening, everyone, and thank you for joining us for tonight's special Woo You event with Dr. Eric Conley. His topic tonight is understanding the legal nuances of keratoconus management. I'll be your host tonight. My name is Dr. Ariel Sorenzi. And a big thank you to Glaukos for supporting this event with a medical education grant. So this will be worth 1 hour of CE, so please be sure to attend for a minimum of 50 minutes. For your COPE certificate, please fill out the survey link that will be in the chat, and it'll also be there when the webinar ends. CE certificates will be delivered via email and sent to ARBO with your OE tracker numbers, and we'll also have a QR code at the end of the event, so if you have your OE tracker app, you can go ahead and scan that on your phone. Otherwise, you'll receive those CE certificates within about 4 weeks. We will save questions towards the end of the presentation, so please feel free to ask them in the chat or the Q&A box. And then if you're on your phone, you can find the Q&A section either at the top there or the chat function under the 3 dots under More at the bottom. So we're going to launch a poll real quick. These polls are really important because they help keep these Woo You presentations free. So we kindly ask you to go ahead and fill out this poll, and then we will ask you to complete to redo the poll at the end to show all of the awesome things that you've learned tonight from Dr. Conley. So I'll give you guys just about 30 more seconds to fill that out. All right, great. So I'm excited to introduce our speaker tonight. Dr. Eric Conley graduated with Clinical Honors Distinction from Salus University in 2006. He was selected for residency in ocular disease at the Baltimore VA Medical Center. And during his residency, he performed specialized clinical rotations at the Wilmer Eye Institute at Johns Hopkins University Medical Center, Mid-Atlantic Glaucoma Experts, and the Retina Care Center. He was honored as the recipient of the National Glaucoma Society Residency Award in 2007. And following residency, Dr. Conley served as an assistant professor of optometry and director of continuing education at ICO. During his tenure in Chicago, Dr. Conley has also served as the chief of ophthalmology, optometry, and optical services at Sidney Hillman Health Center, and concurrently attended the Loyola University School of Law, earning a Master of Jurisprudence degree in health law, hence his expertise in tonight's presentation. Dr. Conley serves as a medical expert in ophthalmic matters and provides case review for several national malpractice law firms, as well as the state of Connecticut Department of Licensing. He lectures internationally on both legal and ophthalmic issues. So he has a lot of great knowledge to share with us to make sure, we're practicing safely and don't find ourselves, on the wrong end of a lawsuit. So we're super excited and thankful to have him tonight. So here is financial disclosures, and I will have you take it from here.
Thank you so much. I really appreciate Woo University, certainly Glaukos' support, and everyone attending tonight. I obviously always start my legal talks letting you know that this is not professional legal advice. Certainly get an attorney if you're having some legal issues within your practice or within your private world. Obviously, I think that it's good to kind of take a 30,000-foot view here and just kind of look at law, generally speaking, and then we'll dive into some of the components as it relates to keratoconus management, because things have changed as the standard of care has changed. So we're going to look at private law and public law. We're going to look at certainly the potential liabilities in our referrals and those co-management relationships. And we want to find certainly ways to mitigate the risk that can come to all of us in practice. Thankfully, as a profession, we are a group that really has very low malpractice liability insurance costs, because we generally have very low malpractice rates that happen to us, which is wonderful. Part of that has to do with our certainly our relationships that we form with our patients. I think they go a long way in making patients feel more comfortable in the care that we provide. When you or myself or any of us as providers walk into a clinic in our patient practice, we have a wide range of ethical, moral, legal considerations that go along with the medicine that we need to provide for these patients. And so how you speak to patients, the procedures that you select, documentation, billing, we make a conscious choice every day, basically, how we're going to provide the highest level of care in every encounter. When it comes to the two types of law, the big areas are public law and private law. So what are we talking about here? Well, public law relates to the government and it's dealing with individuals and businesses. So you think of labor relations, you think of taxation, antitrust, environmental, and of course, criminal law. When it comes to private law, it relates to the rules and principles which regulate the rights among people. So that's contracts, property law, and what we call torts, which is really about civil lawsuits. Lawyers get a little bit of a bad rap when it comes to these lawsuits, and depending on where you are located in the country, in New York here, we have a significant number of attorneys, and in DC and other states. And so you may see more advertisements for lawsuits and suing. They really do keep us as people very civil, and that's why we call it civil suits, because if somebody does happen to harm us, it's a way to go and rectify the situation in a court rather than taking matters into our own hand. We as providers, of course, are subject to both public and private law. So it all starts with that contractual relationship you're making with your patient. So any legal contract, no matter what we're talking about, has to have four elements to be valid. So both parties have to be legally competent. And this is why technically you cannot see a minor in your practice without a parent if they're the policy holder. So anyone who's mentally incompetent certainly would need someone as a chaperone or helper there to guide them. But our minors who are 16 or 17 who can drive to the practice technically should not be seen unless a parent is present. There has to be an offer and an acceptance of the terms. Typically, we talk about money exchanging, but sometimes it can be in other places. I promise to, build a fence for you if you let me have my eyes examined. So there are bartering that can happen as well, and it still would be a legal contract. If there's any part that's illegal, then the whole contract is null and void. We have a kind of different type of contract, and that is that we're under no obligation to engage in practice, or for that matter, accept professional employment. So if I'm walking down the street and someone gets hit in the eye, just because I'm a physician doesn't mean I have to go over and help them. I certainly would, and I would try my best, but it's not something I'm obligated to do simply because I'm a provider. Relationship is consensual. The patient is seeking us, we're accepting them, and we move forward with the process of determining the terms of that contract. Once you're in the relationship with the patient, things change. You can't simply end a contract or relationship with patients, so unless certain things are met. So if the patient is cured, meaning they have a condition like pink eye, conjunctivitis that we treat and resolve, technically we could end the relationship at that point. If they have an ongoing condition like keratoconus or glaucoma or macular degeneration, something that is chronically problematic, the rules are changed because you simply are not going to cure the patient, you're going to be managing them. If the patient is in agreement with the physician to end the relationship, that's fine. A patient can dismiss us, but we have to do something called withdrawal from the contract, which is different. I'm going to talk about that just briefly because it has some implications for us as providers. If you withdraw from a contract, meaning the relationship with your patient, prior to a cure, it can lead to what we call abandonment charges, and that's basically a breach of the contract that you've signed. So we want to avoid that, and what we're going to do is provide sufficient time for patients to find a replacement provider. We've all had that patient who maybe is really difficult, they're not very friendly to our staff, or they're not complying with our medical regimen. Those patients do sometimes need to be moved on to another provider. And the easiest way to do this is just say, I think our philosophy is really aren't lining up, and I want you to get the best care, so I'm going to send you down the street to Dr. So-and-so, and hopefully Dr. So-and-so isn't mad at us for sending this patient over. We cannot terminate care without documentation that someone else is now managing. And there's been case law on this. This is the Maltempo case. The other part is that the courts can compel us to continue treatment even with a difficult or challenging patient to our practice. For instance, if let's say we're in a very rural area and we're the only provider around, the courts may say to the patient, you need to satisfy X, Y, and Z in terms of behavior or compliance, and the doctor, you must continue to see this patient. But that's not common. State regulations in one of the states I practiced before, which was Illinois, this basically a very clear process for abandonment. You can lose your license to practice. You certainly can be fined, and this is in other states as well. Some of them are silent on abandonment, but it is in certainly some of the bylines of many of our laws. After we've basically ended a relationship with patients, we have a relationship or a duty to reach out to a patient if something is newly discovered about either a product or a procedure that we had performed or prescribed during the relationship with the patient. And so for us as optometrists, we're not implanting IOLs into the eye. If there was one that we found was, problematic, the surgeon or ourselves would need to be able to reach out to those patients and guide them in how to go to the next steps. So, assuming we legally have agreed to care for a patient, what legal issues are of most concern? Well, we are an evolved practice, right? So our profession in 1941 was very different than what it is today, right? We have back then an optometrist basically being told that they had not exercised reasonable care and skill in examining the eyes and the fitting of glasses on the eyes. This was the actual lawsuit. And the plaintiff had suffered headaches. This is the harm. He was nauseous. And in Georgia, they said he was backward in his schoolwork, so he probably wasn't doing too well. At the time, the award was $75 to that plaintiff, about $1,400 in today's dollars. And, certainly the type of care we were providing them without therapeutic or diagnostic abilities, this would be the typical lawsuit. In 2024, we are the leading providers of primary eye care nationally. We also, in 4,300 communities, are the only source of primary eye care. And so we've been doing this for a long time. We certainly diagnose vision problems and prescribe contacts and glasses, and we've done vision therapy, low vision, but we have evolved. And now we diagnose and manage keratoconus and glaucoma and other conditions, either prescribing medications or even performing procedures. We still reach out to our colleagues in ophthalmology to do surgical care, and those referrals matter, and we're going to talk about that in a little bit. When you look at malpractice now, because of our scope, when we fail to refer a patient like this one, where we've all had this 50-year-old patient call our office, basically tell us we're having flashes, some type of issue with vision. If this doctor here decides to tell the patient, hey, it's Sunday, I'll see you tomorrow on Monday when the office opens, and the plaintiff suffers an off-MAC retinal detachment, you're running the risk of having a lawsuit. And this is a $2.5 million award to the plaintiff. So we're going to talk a little bit about 1 million, 3 million, or 2 million, 4 million plans, or even higher. And so you have to be aware that you could be liable for these large sums. So malpractice issues really come down to a few things. We have immediate injury during surgery or just prior or after, basically kind of a surgical or treatment-related injury. We also have failure to diagnose a condition such as keratoconus, glaucoma, things that could lead to loss of vision or even loss of life. And then there's the incorrect treatment or mismanagement. And we'll be chatting a little bit about how that can happen even in keratoconus if someone is using off-label, un-FDA approved methods. So one of the things that's important, as I mentioned, is we have a very different malpractice trend. We also have a difference in costs. Malpractice premiums for ophthalmology are about 10 to 20 times that of what we pay as optometric provider. And a lot of this is, again, a result of surgical differences between us. The lawsuit process, should you ever have to endure this, is not pleasant. We want to talk about how it begins, what the steps are, and what your responsibilities are in the process. So first of all, your patient would be considered the claimant. They're going to be the ones to initiate the legal proceedings against us. This is a very kind of challenging process for any optometrist to go through because, again, we walk into an office every day trying our best, and to be sued is something that we take very personal. And, there's more than just the economics piece of this. Once that process has been initiated through a plaintiff's attorney and you get a summons in the mail, there's a response by the defendant. Then we move into discovery, trial proceedings if the court does elect to hear the case, and then we eventually move on to judgments and appeals and collection. One thing I really want to impress upon us all is the response that we will provide as the defendant. You must respond with a guilty or not guilty plea, typically within 30 days. If you don't respond, basically within the designated period, it implies that you are guilty. What something would happen is called summary judgment, and basically the plaintiff would win, and then there would be an amount, and the case is over. You've lost. So you never want to delay opening or responding to legal summons. Get an attorney promptly, talk to your medical carrier promptly. You definitely want to make sure that you are not holding off on this. It's very common to kind of feel like shocked and just do nothing. That's not what we want to do here. The next part is discovery. And so discovery is where, the plaintiffs are going to request records from your office. They're going to want any type of corroborating evidence. So it's not uncommon for us to open a chart and go, ooh, back in the days when we had paper records, to say, oh, I forgot to put this in. Let me clean this up. You don't want to touch that chart. You're not going to try to change any trivial details or major items that are missing. This is clearly something that will end the trial very quickly. If proceedings have started, the patient and attorney probably already have a copy of your record that they are asking you for again. They're looking to see if it has been altered. Now we are a lot in the phase of electronic medical record, what we call EMR, or EHR for health record. And you would think, hey, let me just delete some things and type over it and clean it up. Well, there's something called metadata, which is every keystroke that you make underneath the screen is there. So if you hit backspace, delete, retype, it all shows up what was there previously, what you changed it to, and when. So in the beginning of this, what we call metadata, there was no discovery for that, and you could get away with it. The laws have caught up there. So you don't want to ever alter the record. More importantly, this is the biggest pearl you should take away tonight of all of them. Any records request by a patient or a lawyer always gets put on your desk as the provider to review that chart before it goes out. And then you have a record of any chart that's ever been signed out of your practice. Patient says, oh, I'm moving to Texas. I need my copy of my record. Great. The doctor will review it and you'll be able to get it in a week or whatever your timeline is. You don't want to just hand the patient at the front desk a copy of their chart. You don't know what was out. You don't know what was sent. And really, at that point, it's gone. The next part is basically going to come down to interrogatories, depositions. These are painful 20, 30, 50-minute episodes, hours long, basically being questioned over and over. They are not something you ever want to go through. And again, it's something that we're going to try to avoid by doing the right thing on the front end. Negligence or malpractice is really what we call a failure to use due care. And so malpractice in itself is an all or none phenomenon. you have to have all of these things present in order to be successfully sued and lose the case. So we want to make sure that there's a duty of care or a standard. And for almost every condition that I can think of, there's a standard. We know how to treat things and we move forward. If something new ever comes along, then it may not have a standard and we would discuss it in court. There's a breach of that duty. There's certainly an injury, whether it's loss of vision, certainly loss of function, and then there's what we call causation. We're going to touch on these each briefly. So negligence is very simply this. It is conducting oneself as a reasonably prudent person would do in similar circumstances. So if we're talking about driving a car, it's more about, hey, have we, swerved into the other lane? That's not a reasonable act as a driver. So that's why we might be sued if we cause an accident. As physicians, it's more about how we handle a case from start to finish. So how does that work? We are optometrists. There are our counterpart, our ophthalmology. In the past, we would have said, hey, we are not practicing the same way an ophthalmologist practices, so we shouldn't be compared to them. In the olden days, it was, against those providers who do reasonable and ordinary care in the same neighborhood, in the same general line of practice, who exercise in like cases was sort of the legalese. In this day, we are compared, generally speaking, to any ophthalmologist or other optometrist provider because the standard of care for treatment is essentially the same. And at this point, even rural or urban settings really don't have a distinction when we talk about it in the same neighborhood, because in the olden days, somebody who was maybe in a rural practice didn't know about a new technique or treatment that may have started in a university in the urban setting. So with the internet and online and everything else, there's really no excuse if you're practicing in an area that's maybe more remote. So the other part, of course, is it reasonable care? It's not measured against experts in optometry or experts in ophthalmology. It's against the general practitioner. And so the average physician, same line of practice. Now, there are some times where you can have extraordinary care, like an alternative treatment or something experimental, if there's a reasonable minority that recognizes it as reasonable medicine. And then there's something called the Hail Mary, which is, hey, this is an unrecognized treatment that's never been tried before, but basically it's applied after everything else has failed, and perhaps vision loss is imminent, or even, obviously risk to life. So we want to make sure we're practicing basically the way we should be practicing, and then we would avoid a lot of the breach of duty. Injury, of course, is, in some circles, it's going to be a nerve that becomes cupped out and loss of visual field and glaucoma. In our talk tonight, it's going to be about how a cornea moves towards scarring and vision loss in keratoconus, as you can see here. So causation is the one that really drives home whether the case is won or lost. Injury is pretty easy to see. If somebody no longer has vision or a visual field, there's an injury. The case always rests on, would the injury have occurred otherwise based on what we've done or didn't do? So if I have a patient who walks into my office, their pressures are in the 30s and 30, 40, and I simply send them on their way, then it's very predictable that they would lose vision from my inaction. Likewise, if I have a patient who I should have detected keratoconus or have symptoms that they're having vision problems and they don't detect the keratoconus and they go on to vision loss, that is a foreseeable result of my negligent conduct. So again, it's an all or none phenomenon. It's why most cases are not won against providers. And really, we have to make sure that we are doing our best to avoid negligence cases in the first place. Every case is unique. The breach of duty and causation are often those determining aspects of the case. We have jury verdicts, we have arbitration, very difficult to predict. I've had cases where I felt, we have slam dunk, we're going to win. This is a suit that really should have never been brought against a provider, and yet they still have lost. and if others where things were a little bit more challenging and we won the case. Arbitration is something that you'll always see argued for by large corporations when you sign your iPhone updates and Verizon phone. They all have arbitration clauses. And the reason for that is that juries are sympathetic. Arbitration judges really look at the letter of the law and really aren't interested in the emotional aspects of somebody losing their vision, losing their job. They really just want to know the facts of the case. So a jury verdict is always much more dangerous to a defendant than an arbitration would be. Insurance companies, unfortunately, they will offer settlements where a percentage of the cases, you may object. You may say, hey, I'm the doctor. I didn't do anything wrong here. The insurance company, if they see that the case is not really a slam dunk for them to have a victory, they sometimes will settle it, even though you may not want that. Medical malpractice or negligence, it has both civil and regulatory implications for us. We really want to try to mitigate the risk here. And so we want to get into looking at, something that happens in our offices every day, right? 18-year-old Caucasian male, itchy eyes, decreasing vision, doesn't like his glasses, doesn't like night driving. And he's thinking, hey, maybe LASIK would be great for me. We really want to kind of drill down on what his issue is. He's healthy, he's got no allergies and no meds. Vision with his current glasses, 20/20, 20/25 in the left eye. And so you do your best refraction and you really don't get the left eye clearer. It's a little better, but not 20/20. So we're going to look at the rest of the eye, of course. You do your examination. And really what you're finding here is besides some pretty large cupping and a little bit of allergy in the lids, a healthy looking eye to you and me. So what we find sometimes is we're going to check the nerve, make sure those large nerves have good healthy tissue, make sure the retina is intact, that there's nothing going on. And a lot of times what I see in these cases, it'll say, hey, allergic conjunctivitis, a little bit of astigmatism, and mild amblyopia or amblyopia. And so the doctor in this case said, hey, I'm just going to give you some allergy drops, update your glasses, and we'll do LASIK next year if your eyes are a little more stable. We have to ask ourselves, is this medically and legally sufficient? And unfortunately, it's not. That diagnosis of amblyopia, it doesn't explain the progressive nature. Typically, an amblyope knows that that eye has always been poor. And so we really want to be cautious of somebody calling them amblyopic when someone is telling us that things are changing. Additional testing is warranted here, medical, legal necessity. What should have happened is we should have said, hey, don't like that we're not getting clear vision here. This patient is definitely a high risk, and we're going to get some additional testing for this patient. And so when we look here at his scans, this is the right eye. It has a pretty nice bow tie for that topo. If you look at the left eye, it has a little bit of skew, right? The bow tie is not as even. It's kind of wrapping a little bit to the left side. And so it definitely should make you order something else, right? We have to get the answer for this patient. So this is a suspicious topographical data. We have some skew in the left eye. The next test that you really should be trying to find is a Pentacam tomography test. If you don't have it in your practice, which most of us don't, you have to have that cornea person who you trust to send this patient over to get tested. Why do we use tomography? Well, it's the only device that gives you both the front surface and the back surface of the cornea, and that's really important for detecting keratoconus really early. So hopefully you've had some of this in the previous lectures. I want to briefly review it. If you haven't, I think it'll be a really nice tool to know about and understand. So here's this suspicious topography. It's a placido disc, so we really don't know the back surface of the cornea. We just see that this is suspicious to us. This is what we call the sagittal curvature of the front, so it kind of mimics what the topo does. So when you get a tomography or a Pentacam, you're going to see the same type of skew to one side. It's almost the same as what you just saw with the topographer. We get 4 maps when we do a Pentacam. It's called a four-map refractive. It has what we call a front elevation, a back elevation. It has our sagittal, and it has a corneal thickness or a pachymetry. If you're in this space and you do a lot of this work, or if you've been a LASIK provider, you should be able to look at this format and tell me and your patient that they are not a candidate for LASIK and that they are highly likely going to need what's called cross-linking with Photrexa and iLink. Because I can see, and you will see by the time we're done this, the patient already has early keratoconus starting. So let's look at it. These are the floats. These are super useful because they show the front surface of the cornea and the back surface. These two areas here are suspicious for us, and I'm going to show you why. So in a normal, healthy cornea, the purple is the back surface, the orange or yellow is the front surface, and so this is our model eye. These would have posterior and anterior floats, and all the numbers would be zeros. There would be no deviation from the standard. So when we look here at an eye that's irregular, you can see thinning, you can see here, this is just a scleral lens. But if you look at the actual cornea here, you can see that there is actually a little bit of thinning. And when you put the model eye on there, you're going to get deviations. In keratoconus, the posterior surface usually will deviate more than the anterior surface. If it didn't, the cornea would not get thinner. We know that keratoconus causes thinning of the cornea. So when we look here, we can see this area in the bottom and this area in the back surface are elevated, and this is something we want to reconcile. So that's the 13 and 21 that you're seeing right here. And why does that number matter? Well, when you get to 6 microns, so 6 or 2 or 3 or 1, that's going to be 5% or more of the population. Once you get to 7, so you have 8 here, you have 10 here, 13 here, that is less than 1/2 of 1% of the normal population. So these patients become very high risk for being abnormal. When you look at the surface here, you want to make sure that anything under 5 is wonderful, 5 to 7 is cautious, and greater than 7 should definitely be your red line. The posterior float, as I mentioned, it must do more than the front in order to make the cornea thin. So again, the numbers are a little different here. Anything up to 12 or 13 is normal. Once you get above 16, you're back to that 0.5% population. So 16 here, 21 here. These are areas that are concerning to us for our patient. And so that less than 12 is pretty safe, 12 to 16 is suspicious, and greater than 16 is really unlikely to be in a normal, healthy patient. So when we do the map, we get these 4 spots here, and we have to kind of look at all of them together. It's really hard to just look at one scan and say, oh, well, the front surface is elevated, and so they must have keratoconus. If the back surface, if not, then it's not keratoconus. It could be anterior basement membrane dystrophy. They could have corneal ingrowth from a LASIK procedure. Lots of reasons to have just one float that's abnormal. You're looking for all 4 of these to be certainly suspicious. So we call it the map of 4, and I'll show you how that works here. Normally, a cornea is thinnest at the apex. You can see for our patient here, the thinnest point is actually below the apex. It's down here with this little dot, and you can see it's about 507, 509, something like that in here, instead of it being central. So this is another clue that this is an abnormal scan. So we have this 4-map rule. We have skew, we have a decentered or dislocated pachymetry, and then you have 2 floats that are certainly outside the normal ranges. So suspicious front, back, and packs is definitely a possible ectatic map. The diagnosis here should have been corneal ectasia, not mild amblyopia. And we want to kind of look at what the potential implications are here legally and medically that can arise from this failure to diagnose. So clearly with this 18-year-old young man, he's going from 18 to 19, and you can see his posterior floats here at 21 and anterior at 13. The next year, it's now 15 and 28. The cornea is dislocating even farther, and you're starting to see this pellucid kind of kissing dove starting to come together. Well, in the next year, he's gotten even worse. So now he's at 24 and 44, and you can really see the kissing doves more so here. And then lastly, we've gotten to the point where we really have severe steepening of the cornea and very thin and dislocated inferiorly. So this is the area we really want to never get to, especially in today's treatment options. This young man did go into scarring. This is something that we want to definitely avoid. This is a easy malpractice suit. So delaying the diagnosis, not using FDA-approved cross-linking treatment, and that subsequent vision loss, it's a successful malpractice case against any of us. We want to not failure to diagnose. We failed to meet the standard of care. Improper diagnosis, failure to refer, and then improper and delayed treatments are all going to be listed as part of the lawsuit. And unfortunately, it's really an easy claim against us. In the olden days, we were able to put a hard lens on that eye, see the patient through, cross our fingers that they did not go on to scarring and need a transplant. But we now have an FDA-approved treatment that arrests and basically stops this condition in its tracks. If you're not applying it, you're not following the standard of care. What's it cost to us as providers and our malpractice insurance? Well, your 1 million, 3 million policy is basically 1 million per event, 3 million per year. So basically up to 3 events are going to be covered. This case here was a surgeon who failed to diagnose the formfrost keratoconus in a patient. Basically went on and provided laser surgery, and the patient did develop post-operative ectasia. The jury awarded this plaintiff $7.25 million. And so there's a current case for an OD who failed to properly manage keratoconus. They knew that the patient had keratoconus in their teen years, never ordered a topography or tomography, failed to refer the patient for cross-linking, and the patient lost vision. So I can guarantee you this case will go on to be a loss for the provider, and they will have a judgment held against them. Patients presenting with progressive keratoconus and corneal ectasia following refractive surgery require prompt referral to a center that's performing FDA-approved cross-linking. So Photrexa, iLink, those two components together are the FDA-approved version. If you have a provider who's using compounded riboflavin or using a device that's been basically smuggled into the country, they are not following the standard of care. And by proxy, you referring to that doctor, you are not following the standard of care. We know that keratoconus requires the Dresden protocol, which I'll touch on in a minute. It's the gold standard for our patients. We know that the preferred practice pattern from the Academy of Ophthalmology is a prompt referral for patients to get cross-linking. So this is all established. It's easy to bring to court. One of the things that people have asked is, well, what does a prompt referral mean? Well, sadly, we had to deal with our pandemic and patients were delayed in getting treatment. And so some study folks looked at the keratoconus patients who had to delay their treatment of cross-linking. All 46 had progressed and worsened. They lost a line of vision in that 3-month window. So those COVID restrictions disrupted the practice pattern and patients lost vision. So now we have a study out there saying, hey, 3 months losing vision is our time clock. So it used to be, hey, you think they might have keratoconus? Bring these folks back in 6 months, 7 months, 8 months, and we'll see if anything's changed. I'm going to tell you, bring them back in 2 months, bring them back in 4 months. You really want to make sure that this is not active keratoconus where they're going to lose vision in that waiting period. Basically, proper technique is removing central corneal epithelium, what we call epi-off. There's going to be some data I show you between epi-on and epi-off. Photrexa is given. You have to make sure that pachymetry is greater than 400 microns, and then they're going to expose them to the UV light and basically get the patient through that 30-minute treatment. Highly recommend, if you're working with a provider, NSAIDs provide a lot of pain relief, much greater than any type of narcotic. So epi-off compared to epi-on, very different animal. So it's a risk that you really don't need to take. I know some providers like to do epi on because it's more comfortable. They're dealing with kids. They don't want to take the cornea off. I appreciate that, but the data is very clear. This case here, just another successful lawsuit that I've had to deal with. 19-year-old Hispanic male, clearly had keratoconus. Show you the case. The vision's poor. Refraction does not get us to where we need to be. He even has focal apical scar already. So we're already starting behind the 8 ball on this 18-year-old. There's already been a delayed diagnosis. But nonetheless, the provider says, hey, I'm going to give you epi-on treatment. Here's his keratoconus in the right eye. You see it's much worse in the left eye. So here's our floats that we talked about. We're steeper at the bottom. We have a 16 to 20 kind of anterior. We have a 37 posterior, and we're displaced downward with our central cornea. And obviously it's much worse with the other eye. Epi-on is what this doctor chose for this patient. They had an unapproved system that had compounded riboflavin. Basically, they told the patient it was an off-label use of an FDA-approved device and medication. That is not true. This is not labeled at all. This is unapproved. Compounded riboflavin is not a legal drug. And of course, the devices are not regulated, so you don't even know what you're getting. They also went on to charge the patient for this procedure, $6,500. It was a nice bargain. Unfortunately, the patient wasn't told that this is covered by insurance by nearly 97% of providers out there, and that there's an FDA-approved version. You can see where this is going. He's lost a follow-up. He comes back, and now he's got vision that is very poor. He has scarring that's worsened. And if you look at his scan, it's even more dense. If you look at the changes in his cornea, he's in the good eye, he's steepened by almost 4 diopters, and in the bad eye by 20 to 30. So he's now scarred and he needs surgery. So we don't want to have patients getting unapproved treatments. If you're sending to a provider that's doing them, you're going to be also looped into the lawsuit. I've seen it happen in a few states already. So the other thing you want to make sure is that they're doing cross-linking the right way. We had 50% of patients who were needed to be retreated, pediatric patients, if they were given the epi-on version. It's really not necessary if you do it the right way the first time. We see that in a meta-analysis of all the studies out there, that transepithelial or epi-on cross-linking, it's inferior in its efficacy. In this study here that we saw going back just about 6-7 years ago, if they were epi-off, which is the proper way, the cornea really did not change pre and post-operatively. It stabilized. When you looked at patients who had the epi-on version, you could see that the cornea steepened in not only the flat meridian, but also in the steeper meridian. So it's showing you that epi-on, it really does not work as effectively as epi-off. And with younger patients, it's even more important that it is epi-off. You want to make sure you're sending patients to providers that only do cross-linking, Photrexa, iLink. It's FDA approved. It's proven to work. You're not going to run into the pitfalls. If you don't know who in your area, go to this link, www.ilinkexpert.com. That's where you can find who in your area is utilizing Photrexa and iLink. If you're not in this list, they're probably doing it what we call off-label, no label, okay? Last part of this, we want to touch on co-management. Our referrals matter, right? Who are you sending your patient out to? You really want to go visit the practice, of course. You'd like to see the devices that they utilize for procedures. And you want to know what your liability is that you have for the care rendered by them. And you also want to know if you're vulnerable, if you're collecting co-management fees, potentially in risk of anti-kickback statutes. There's been several cases where providers were, provided with tickets to ball games. That is an inducement for your referral. And theoretically, you could be charged for that. Competency is always challenging. We, as optometrists, We were not in surgery with those providers. So we go by their credentials, their reputation in the OR. How can we really know how good they are until we start seeing some of their results? But I would tell you that there is one thing you can do, and you can make sure that they're using the latest technology and that they're doing right by the patients. It's one thing to try and say that, oh, we have a study going on. That study has to be genuine. And so I don't have a problem with providers who are out there trying to find a better way, a safer way, a faster way, but it can't be at the expense of our patients' health and their pockets. So one of the things that we want to make sure is that the patients are getting treated with FDA-approved devices or instruments. We also want to make sure that they're not getting off-label treatments. These are things that can really interfere with the quality of the outcome. Co-management is fine. It's a legitimate type of care. CMS and the Office of Inspector General, they have considered co-management, when done appropriately, is perfectly legitimate. But you cannot be taking exorbitant fees because you're a better referrer than another provider, and you can't be taking gifts, including free CE. A lot of providers go to an ophthalmology practice locally for free continuing ed. That's another inducement. And so again, it depends on how fine you want to read the letter of the law, but you have to be careful that you're really referring patients to the best provider without undue influence. So you've all been through this wonderful series provided by Wu University. You certainly are now amazing ectasia clinicians, and after tonight, hopefully brilliant legal minds. I want to hit a few last pearls of things that might help you diagnose this. Certainly, a topography that looks like this is an easy diagnosis. Certainly, this after tonight, hopefully, at least raises a caution flag when you see that the bow tie is not quite symmetrical. But you might even say, hey, I don't even have topography in my office or tomography. And so what can we do here for these patients? One of the things that's important is to be able to look at something you do utilize in your practice, which is an autorefractor autokeratometer. We've all talked about utilizing a retinoscope, look for scissors reflex, but I'm going to show you here how you can just look at your printouts and determine the patient who has keratoconus. So I have two patients here, very similar looking. Both have, over 4 diopters of astigmatism in one eye. And so we want to kind of see which one has keratoconus. For some of you, it's easy to figure out. For others, you may not have used this technique, so hopefully it'll be enlightening. So you have a 23-year-old and you have a 47-year-old. The 23-year-old is looking for LASIK. This is his data. You can see that left eye has a lot more astigmatism. The important part is that we are corrected in the 20/20 zone for each eye. And so again, patients who can correct well are lower risk to us. When we look here at our scans, you don't see those elevation maps, +2, +2, +4. Cornea is very thick and it's very symmetrical. In the other eye that has 4 diopters, we see a very symmetrical bow tie, and we don't see any elevations in those bow tie areas. In fact, we see negative numbers, which are very consistent with regular astigmatism. And so this patient, even though they have a far amount of cylinder, more than our typical patient in one eye, they really do not have any keratoconus. And when you look at them serial over time, they're not progressing. And so even in the more sophisticated eye that has a lot more cyl, it's not changing over the years. So this patient, even though they have a ton of cyl, does not have keratoconus. The other patient here is 47-year-old, and this is his first exam since he was a kid. He's telling you that his vision has been terrible and the bad eye is his left eye for 10 years. And when you refract, the best you're getting is about 20/30. You also notice that the AR is not the same as your refraction. So nothing's really adding up. You can't quite get the vision. But this guy's 47, so maybe cataracts, maybe retina, maybe glaucoma. So you're going to do a little bit more to make sure they're healthy. And when you look at the right eye and the left eye, there's really nothing going on in the macula. The nerve is healthy. And so you got to pin your efforts on the cornea going forward. So here in the good eye, you see a little bit of difference. This is 43, 41. So about a 1.5 to 2 diopter difference between the top and bottom. You can see we're getting a little bit of 7s and 8s here, and we have a little bit of displacement. The other eye, it's clearly a pellucid ectasia eye. So even though he's never seen folks for a long time, he already has scarring, or at least he has steepening, excuse me, and he has the displacement. You can see that cornea center is moved downward. You have the pellucid here showing up. So what do you do with this 47-year-old? Well, at this point, maybe he's been cross-linked naturally, maybe not. You're going to be following him very closely, 3 months. You're also going to tell him to bring his children in for evaluation because they're high risk for keratoconus as well. One last little test here. Got a few minutes left. I'm going to give you one more group here. There's 4 different cross-linking printouts here. You have plus 1.5, 5, plus 550 minus 525. Does this patient have keratoconus? Plus 250 minus 225. Does this patient have keratoconus? -1, -2. Does this patient have keratoconus? Plus 3, minus 350. So we have all these different high SIL patients, mixed SIL patients. Can we just look at the printout and know who has keratoconus? My answer to you is yes. I'll show you this patient A. You can see here, despite the SIL being about a diopter, no major spikes here. The fellow eye that has 5 diopters of mixed astigmatism, very beautiful bow tie, no elevations in those areas, no thinning of the cornea. So A is out. The other one with high SIL, 3 diopters, 3.5 in the D group. Same thing. This patient's older. You can see this patient's in their 60s. Very irregular corneal thickness map. This is from ABMD. There's no evidence of keratoconus. When you look at the other eye with all that SIL, same thing. No keratoconus showing up, just anterior basement membrane dystrophy. So now we're down to the last 2. We're going to pick the one that has the less SIL just because we've been going after the high SIL ones without success. This patient here, you can see again, the refraction in the right eye does not match the autorefractor, and we can't get better than 20/25. Patients should be able to correct, especially young, healthy patients, to 20/20 until proven otherwise. So it's got to be a clue that you respond to. When you look back at this patient in 3 or 4 years previous, 20/20 in each eye, very little prescription. 20/20 in each eye, very little prescription. When you look at the scans in the right eye, you're seeing a little clue here. 41, 43. This is the good left eye. A little bit of steepening, a little bit of steepening, a little bit of displacement. When you go to the other eye, there it is. So again, why couldn't we refract this patient to 20/20? Because they already have keratoconus starting. You see plus 25 float, plus 48 float, displacement downward. All 4 maps are showing you keratoconus has started. This patient gets sent out, got to get them treated, send them for cross-linking, basically have their procedure done, and we move forward to the other eye because you know it's coming. The standard of care has evolved. Keratoconus has to be diagnosed and treated promptly with FDA-approved Photrexa Iling. You're going to get medical legal increase to your practice. You have to handle them systematically. No record ever leaves your practice without your review and release. And you want to utilize all the available tools to detect keratoconus in patients with decreased vision unexplained by other ocular findings. The retina is clear, the lens is clear. You're going to have to go after that cornea. I would tell you that just like glaucoma, we all invested in visual field machines. We invested in certainly OCTs that could look at optic nerve fiber layer. With the risk for glaucoma, or excuse me, the risk for keratoconus malpractice, I would argue every practice should have a topographer, and if it were feasible, a tomographer like a Penacam, because you really have to be able to tease these patients out as early as possible to prevent a lawsuit.